Hi, thanks for joining us for estate planning strategies and avoiding probate. I'm Anthony F. Russo, and I'm here to deliver some information to you to help you start your planning process. When most clients come in to see us, they usually want to be able to pass their estate quickly and easily without a lot of cost and expense. And they ask, how could they do that? Their friends are all talking about that. Well, it's just not an easy answer. There's a lot of preparation before that, but to achieve this goal, we start with trying to explain some important key terms that they'll basically need to understand so they can build upon them. We call this preparing our foundation. We prepare this foundation for you to learn, and then you build upon this foundation. So try to sit back, listen, enjoy, and absorb as much as you can. If you need to get up or you want to think about something, push pause, but come back to us. Just don't let it play while you're thinking about something else, because we are building in that building block approach, and you may lose some of the steps in between. All right, so we hope you enjoyed. Let's talk about what's included in your estate. Your estate includes all of your assets, all your personal property, or your real property, or your investments, or your retirement accounts, or your bank accounts, or your life insurance policies. Pool that all together, and that's part of your estate. When we die, do we have to pay taxes? Are there estate taxes? Both the federal government and New York State impose estate tax. Of course, you can transfer to your spouse an unlimited amount without paying taxes. But under the federal tax law, you have an exemption of $12.06 million for persons dying in 2020. For New York, the state tax exemptions is $6.11 million for persons dying in 2022. It means that each person has this exemption. They have a $12 million federal and a $6 million state exemption. If you have a spouse, then you can double those exemptions. You basically pass $24 million through your federal tax exemptions and $12 million through your New York State tax exemptions. Full tax planning, and every attorney who talks about estate planning with you will always go through the amount of assets you have to see if tax planning is needed at this time. Well, invariably, it always comes up, what is probate? What is this thing I'm hearing about probate? My neighbors are talking about it. My friends are talking about it. I've heard about it. I went through it when my parents passed away. But things have changed now. Things are more expensive now. Costs are higher. So probate is defined as the legal process of authenticating the person's last will and testament. Probate is required whenever assets are to be distributed under the terms of a person's will. And when assets are distributed under a person's will, that means that that asset had no beneficiary on it, there wasn't a co-owner on it, and it wasn't in a trust. When it's in your individual name, without a joint owner, without a beneficiary, then you're going to go through probate, which is that legal process of authenticating the will through the court system. You submit the will to the surrogate's court, you'll notify all the heirs, issuance of letters testamentary is expected. That will give you the legal license to start collecting assets and identifying beneficiaries. You pay the debts, you pay the expenses, you distribute the assets as directed by the will, and you've now done, you file an inventory, and you've now done what you need to do to process and probate the will. So why do people want to avoid probate? What's that whole thing about? Well, the reasons are court costs, attorney fees, delays, challenges, and Medicaid estate recovery claims. Let's talk about them individually. For court costs, for an estate worth $500,000 or more, there's a $1,250 filing fee. There's additional fees could be necessary for guardian ad litem proceedings or public administrator. Well, $1,250, it goes on a sliding scale. Right now, if you have $500,000 or more, it's $1,250. That's at today's dollars. Next is attorney fees. Usually when folks are going through probate, they'll hire an attorney, prepare all the paperwork, get it through court, and get it processed so they can start distributing the estate. Attorney fees are generally 4 to 7% of the gross estate. Now, we don't take it from the entire estate to have beneficiaries or co-owners because we didn't do anything for that. You just showed your name and you showed your ID, and you said they saw you were a beneficiary or co-owner, and they turned the money over. You didn't need probate for that. But many houses, when one spouse has passed, or if something that's individually owned, are $500,000 or more. So at 4% of a $500,000 estate is a $20,000 fee to lawyers. It's expensive to use the lawyer. Well, many people don't like that. What about delay? Well, probate can take months or even years when there are contests, but assuming there are no contests, we can get through Nassau, Suffolk, 6 to 8 weeks. We'll get letters testamentary, usually for non-contested matters. In New York City, it's going to be 6 or more months, which is a common time, usually 6 to 9 months in Queens County, which we're used to, Brooklyn and whatnot. While probate is pending, the executor has no control over any of the assets. Can't sell them until you get the legal authority to do it. You've got to carry them, expenses begin to add up. And you want to try to avoid family arguments because time produces thoughts, thoughts produces arguments sometimes, and arguments will sometimes tear your family apart, something that you would never let happen had you been here, and you don't want to let it happen when you pass away. What about challenges? Well, you see, any person that could inherit your estate through the laws of intestacy can challenge your will. So it could be your children. If you disinherited one child, that child has a right through the laws of intestacy to inherit, so they could step forward and challenge your estate. They all get a copy of the will and they get notice so they can come forward and challenge. It's also available to the general public. The probate petition is filed, and I can look at yours, you can look at mine, creditors go up and look at that. They look at the names, they try to match it to their list, and if they find it, they file a lien with the court. In this process of probate, it invites heirs to assert their challenges to the will. The biggest problem with probate lies in Medicaid. See, Medicaid comes in two forms. We're talking about long-term care Medicaid. We're talking about care in your home or care in a nursing home. Assuming that you're eligible to get Medicaid, that'll be in another couple of webinars, we'll talk about that. Medicaid will pay for your long-term care needs. But you must understand that Medicaid always wants their money back. Where does Medicaid get their money back in New York State? Only from one place, and that's your probate estate. If you allow your estate to go through probate, Medicaid has a right to assert a claim against that asset that goes through probate. So if you're going to use the Medicaid system, you probably want to get a benefit rather than a loan. To get a benefit, you stay out of probate. To get a loan, you stay in probate. And when the probate estate goes through, Medicaid will assert their lien. And when you sell that house, Medicaid will be there to take whatever they have as a lien. Well, knowing those definitions in that foundation, we start to see and talk to people and ask, what is your estate planning goals? And they'll ask, well, what they should be. What should they be? What should our estate planning goals be? Well, let's talk about that. I think you'd like to plan for yourself and your loved ones without giving up control of your affairs. You probably want to plan for the possibility of your own disability. You'd like to give what you own to whom you want to receive it, the way you want them to receive it, and when you want them to receive it. You'd like to save every tax dollar, professional fee, and court costs that you legally can save. You like to plan for the future of your long-term care needs. Avoid Medicaid estate recovery claims. If you need Medicaid, you don't take the money back. With those goals in mind, let's talk about what the common estate planning techniques are. What do people do when they want to plan? Some do nothing. No estate plan. They go through the laws of intestacy. New York will tell you where to leave, or who to leave your assets to. Some people write a last will and testament. They're going to go through probate, but at least they have their assets down in the will, and they know where it's going to, and it's going to have court involvement, but it's going to get to the right place. And there's joint ownership. Put somebody's name on an account, it won't go to probate, it'll go to the joint owner. Then there's beneficiary designations. Put a beneficiary in a trust for account, it'll go to the beneficiary that you leave on there. It won't go through probate. You can also get money out of your estate by gifting it. And you can also plan using a living trust. Now, it's a trust. Is revocable and irrevocable, but the trust never dies, which is why it's always living, and it's there during your lifetime. You can have this trust while you're alive. It'll cover you during your lifetime, during a disability, and it'll be there when you pass away. Well, let's talk about these plans. When you have no estate plan, New York State will provide you with one. Assets will be distributed according to the laws of intestacy. The laws of intestacy may not reflect your true intentions. But people do this because they want to avoid probate, or they just didn't know to plan. But it results in what's called an estate administration, which is a process identical to probate. You're still going to pay the same fees, you're still going to have the same delays, you're still going to have the same publicity, and you're still going to pay Medicaid back when you pass away. So doing nothing probably isn't the best thing to do. Then maybe we'll do a last will and testament. Once again, what does that will control? It controls only an asset that's in your individual name, that does not have a joint owner, that does not have a beneficiary. It's a set of instructions on what to do with the assets of your estate when you pass away. It names executors, the people that are entrusted with the duty of passing your assets along the way you wished, trustees to manage your money, and guardians if you have underage children. Of course, what's the disadvantages? It's probate. Probate, you're going to have to spend all those fees, hire the attorney, pay the 4%. Then ultimately, if your parents or if you got Medicaid benefits, your children are going to have to pay those back from the probate estate. The probate estate is subject to the Medicaid estate recovery, same as the administration estate. A probate estate, Medicaid will come in and take their money back that they gave you. You won't have a benefit, it'll be a loan. Well, avoid probate. About joint ownership. Some people come in and say, you know what, I put my son on all my accounts. We're joint owners now. How many kids do you have? I got 3. He's going to give it to the other 2 when you die. Oh, of course, he's a great kid. Well, of course, he is a great kid. He probably will do that. But the point is, he doesn't have to. A joint tenancy with rights of survivorship, it automatically passes to the surviving joint owner. There's no probate required. But people think when they put the child or somebody else on their account, they've reduced their resources. They haven't. If your name's on the account, Medicaid believes you can get the whole amount, and that's a charge against you. What about if you put your son on your account and you didn't know he had a judgment or lien against him? Your asset now has that judgment or lien. What about that son who said he's going to share? Does he have to? No, not by law. Can't be forced to. Morally, he should, but he doesn't have to. We never really see that problem much, but it's out there and we need to tell you. So joint ownership is good in certain circumstances, but not the total way of planning. How about beneficiary designations? We use those a lot on our IRAs, our insurance policies, and bank accounts. They're great to avoid probate because when there's a beneficiary named, you don't have to go to probate. It goes to that beneficiary. However, say you named your, God forbid, you named your son as a beneficiary, and God forbid he passed away. Well, under the will or under the laws, it may go to his or her children, but when you have a beneficiary named, it's not going to go to their children. It's just going to stop right there. And if that beneficiary passes, our asset's going through probate. What about if that beneficiary, your son, gets a disability and he's on governmental aid, he's getting Medicaid. Now you've knocked him off that aid because you've given him too much money. What about minor beneficiaries? What about when you're under 18 and you're going to be a beneficiary of an account? Well, your family is going to have to go to court to get a trustee name to manage that money until the child is 18. And then when they're 18, they're going to turn it over. You might have set forth in your own planning or your own mind how you want that money to be spent. Well, you have no right to tell that trustee that you're going to be deceased and that trustee is going to be named after you passed. Maybe you didn't want that money to be distributed at 18 like it would in an administration. Maybe you didn't want that child to get it till they're 21, 25, or 30. Well, that's why beneficiary designations fall short sometimes. You can't control that. How about giving your money away? A lot of people like to do that, but no one's going to give all their money away. We put the slide in here because we wanted to tell you that the average now is $16,000. You can give $16,000 per year to as many people as you want without filing a gift tax return. There is no gift tax until you give more than 12.06 million in New York. However, when you do give a gift of over 16,000, you have to file an informational return. That gift tax, when you file it, reduces your estate tax exemption. So if you had a 5 million and you gave $1 million away, you have 4 million now. When you give it to somebody, there could be creditors on them. As soon as you put it in their name, judgments, liens, divorce is now attached to that. And now maybe you need Medicaid benefits. Now you gave money away. You just can't give your money away and say, Medicaid, pay for me. You have to give it away a period of time before that. And so it could be potential adverse Medicaid consequences. Well, when you don't like all those things, and you don't like that probate, can't do everything with a beneficiary or joint owner. You think about using a trust. What's a trust? Trust is a big will. It's a set of assets on what to do, it's a set of instructions, I'm sorry, on what to do with your assets when you pass away. The will controls what's in your own name without a joint owner, without a beneficiary. The trust controls what the trust owns. So if I did a trust, I would transfer my deed from my name to my trust name. I owned my house, now my trust owns my house. What's the difference? The rationale behind the trust is, you see, we all die. So when we die, anything we owned that has a joint owner, that doesn't have a joint owner, doesn't have a beneficiary, well, it's got to go through probate. But a trust never dies. A trust says, hey, when he or she dies, take these assets and distribute them this way. There's no probate involved in that. There's no filing fee. There's no 4% to some attorney. There's no filing papers in court disclosing your kids' names, your asset level, and there's no inventory file telling them what these assets were. You're outside of the court system. It's like I said, it contains a list of instructions on how to manage and distribute the assets during your lifetime, if you should get incapacitated, and at your death. It can be changed at any time. Once you do a trust, you could change the terms of that trust. This is called a revocable or revocable trust, however you'd like to say that. You can appoint yourself as the trustee. You can control your own trust. This trust is not being used to show Medicaid you gave an asset away. It's being used to avoid probate and make planning simpler and easier. The revocable trust uses your social security number as tax ID number. So all taxes on any revocable trust assets will be paid at your individual level. There is no trust tax rate that you have to pay with this. So you're using this trust, and you're planning just like you would plan with a will. Then you're transferring assets into the name so that the trust controls them. So when you do pass away, you'd passed, but your trust didn't pass. Your trust is still alive, and your trust says when he or she passes, do this with the assets, and you simply follow the instructions. You could do it the day after someone dies, although I know that's harsh to talk about, but you don't have to wait 6 to 8 weeks. You could do things immediately. And what does that do? It basically makes everything quick and easy, so whoever is grieving, they can grieve. They don't have to worry about doing all this other extra work. It's going to be done quick and easy for them. And most of the attorneys, I know we're always here for when somebody passes, we always have somebody in to talk about how this operates. Well, a living trust, assets by a living trust avoid probate upon your passing. Like I said, you must, to be effective in avoiding probate, ownership of the assets must be transferred to the name of your trust. And these trusts can be used for single folks, married folks, tax planning situations, special needs situations. Well, that was a mouthful. Now, we've learned about what's included in your estate. What are estate taxes? What is probate? Why do people want to avoid probate? We talked about the different ways that people plan and the pros and cons of each. But we only touched upon the beginning of this, because now that you know you want to plan to transfer your assets quickly and easily with limiting cost and expense, now you get into that second desire that most people want. They want to know that in the event they need long-term care, how are they going to pay for it? Did they buy a long-term care policy? Do they want to pay it out of their own pocket? Or maybe they want to use the Medicaid system. There are ways of planning that can make Medicaid believe that the assets you own are not under your control, therefore they're not counted against you. To learn more about that, watch on Medicaid planning, crisis planning, and irrevocable trust. That will take you through the second half. Also, after that, watch Understanding Medicaid Eligibility. You'll understand it further. Putting all these webinars together, you'll have a full course on how to plan. And then you come into the office and you sit down and you talk to your attorney. We would love to see you. But when you sit down with knowledge that when the attorney talks to you, you'll be able to understand a lot of this. Usually when people call us for appointments, we'll send out our webinar to them. So watch it. This is a new series of webinars which broke it down a little more, and we'll still instruct them to do that. But once you do it and you watch the webinar and you absorb, and then you go into the next one, when you're done with that, write all your questions down and come in and talk to me. Okay? It was my pleasure. It was nice to speak to you on this morning, and I want you to watch all the other webinars so you can get a full view of estate planning. Thanks so much.